Well, welcome back after uh, turkey, tuna, chicken, or veggie sandwich. I hope they were good. And I'm really delighted to see the crowd that has gathered here. Um, there are a number of my either current students or former students, and I would just advise the speakers who might be fielding some of their questions that they are truly prepared. So watch out. Last quarter, in the winter quarter, I taught a seminar on the topic of privacy and national security. And we had about 25 students. And it was an amazing experience. The way that class was taught, as opposed to lecturing, we divided up into groups of 3 or 4. And each group read a different major work about privacy or national security. We read the book by Daniel Solov. We read Amitai Etzion's book on privacy. We read Richard Posner's book called Not a Suicide Pact about the right to privacy and national security. And each student group presented a different book. And their instructions were to make the rest of the class as informed and feel as though they had actually read that book. So everybody had a very in-depth exposure to the issues that we're talking about today. And it became very clear that there was a life to this subject beyond that very nice undergraduate seminar. And of course, the Snowden disclosures had happened, the 2 lawsuits that possibly Cindy and other people are going to be talking about in a few minutes. Decisions had come down just before the first of the year with respect to the lawsuits against the NSA. The material was absolutely unlimited, basically. And I felt very strongly. I'm a UCLA graduate, undergraduate. I'm a graduate of this fabulous law school. And now I'm a triple Bruin threat because I'm teaching in the political science department. And I love this school. And I feel really strongly that a fabulous university, one of the world's great universities, should be having some things to say about policy making that might be happening 3,000 miles away, but is fundamentally important to who we are as Americans, to who we are here in California, and that we should hold sessions like this and bring people to the campus that might not every day. We have several people on our panels today who either had never been to UCLA or even Los Angeles before, but they're great scholars and writers and policymakers. And so I feel that this is a really important thing to do. So we put together this amazing symposium today. The Political Science Department, the Law School, the Office of Information Technology, we had a couple of student groups co-sponsor this. We've had the Brennan Center for Justice, a great organization attached to NYU, and the Constitution Project, which is a nonprofit in Washington that is strictly nonpartisan, or you might say bipartisan, studying constitutional issues, and they are also a co-sponsor. The head of that organization was a colleague of mine at law school. So we've all come together, and I hope people are learning something and taking something away today. There are many, many people to thank for doing this. I just have to mention a few while I've got the podium, so Cindy, just bear with me for a moment. First of all, from the law school, Dean Rachel Moran, who, when this idea was proposed that we would do a joint effort, just accepted immediately. And the Ann C. Rosenfeld Symposium Fund is a fund that's been over here at the law school for some years to do exactly this kind of program at least once a year. And so their generosity is very, very much appreciated. All the staff over here, Lee Iwanaga, Sarah Crane, Dan Warm, our audiovisual guy, everybody chipped in. And not everybody was used to working with people in the poli-sci department. So we sort of broke some new ground, and I hope these are forging relationships that will stand us in good stead in the future. From our political science staff, all of our staff, Stephanie Ariaza, Tiffany Mulatto, Joseph Reiser, Belinda Sunu, none of these people are here. But this wouldn't have happened if they weren't here. Tracy Ann Yee in our front office. Brendan Zwaneveld, who's one of my former students, but he actually came every day at 2 o'clock to help me do this. And of course, you've seen our great staff of Lebo's Army, as they're called, my student volunteers. And then from the Office of OIT, Office of Information Technology, and the UCLA Chief Privacy Officer, Kent Wada, and I just have to mention one person, and I would ask her to stand. I think she's here. Kelly Aruda? Maybe she's out in the hall? Out in the hall? You want to tell her that her moment of her 10 minutes of fame has arrived? Well, I'll just, maybe it's good that she's not here, Jim, because she was lent to us from OIT, and just a fabulous person, did all this great graphic work and all these things. And I really just wanted to take a moment to thank her personally for everything that she has done to help make this happen. There she is. Kelly, thank you. I just said this is your moment of fame. So I wanted to thank you in person, publicly, because this wouldn't have happened without you. So thank you, and thank Jim and Kent for lending her to do this project. All right, without further ado, we are going to move forward and hear from our keynote speaker. Cindy Cohn is the legal director of the Electronic Frontier Foundation. She's the organization's general counsel. And besides all of her outstanding legal credentials, she is one of the principal litigators in a whole line of cases, which I'm sure she's going to talk about, challenging the surveillance practices of the National Security Agency, including the case of Jewel versus NSA and First Unitarian Church versus NSA. These are really important cases in our court system right now, challenging the NSA's activities. Just to get a sense of how important she is in the legal community, Cindy was named one of the 50 most influential lawyers in America by the National Law Journal. She's been named one of the 100 most influential lawyers in America in both 2006 and last year, 2013. So without further ado, because you can all read the rest of her extensive bio, we're going to hear from Cindy, and I'm going to let her explain whose shoes she's standing in. Cindy Cohn.
Thank you very much. I appreciate the chance to come and talk to y'all. Let me mark my time. Well, first of all, when I get an invitation to come speak by somebody named Cindy, it's really hard for me to say no, because there aren't very many of us in the world. But more importantly, what she said to me was, Dianne Feinstein can't come and be our keynote. Would you step in for her? And no one has ever asked me to step into Dianne Feinstein's shoes before, and I think with good reason, because turns out we don't agree very much about these things. But that was an opportunity I couldn't resist. And I thought for a minute, like, maybe I should do a Clint Eastwood thing, like pretend like she's sitting there. And then I thought, well, that didn't really work very well for Clint, so I don't think I'm going to do that. And I also was going to go through and kind of talk through her talking points about the NSA surveillance, but one of the things that's happening with Senator Feinstein now is actually she's undergoing a bit of a change in her position about a lot of things having to do with the fight against terror. And so I was afraid that if I tried to characterize her position, I would be instantly wrong, and I didn't want to do that. So I think what that means for you guys is the next time she's speaking somewhere, I think you just have to go ask her for yourself to get her position, and rather than try to characterize it, I will tell you mine and the work that I've been doing. So I'm sorry, I can't fill her shoes, and I probably can't even walk in them, but I will do my best to talk about something I do know a little bit about, which is the NSA spying and the impact on all of our privacy and free speech and constitutional rights as a result of it. So what I'd like to do is talk for about a half hour, and then we'll have questions for about 15 minutes. And in that half hour, which I'm going to try to tell you a little bit of what we know about the NSA spying, a little bit about the law, a little bit about what EFF is doing, and a little bit about what you can do. And the reason that I say a little bit about all of these things is that this issue is so big. There are so many revelations, and we aren't done yet, that it really, it's impossible to do it in a half hour, and frankly we could do a 3-day seminar, and I still don't think we would have talked through all of the things we've learned about what our government has been doing in the name that affect our communications in the name since 9/11. But the first thing I want to do is take you back in time a little bit. You know, the Snowden revelations have been tremendously important, but you know, Mr. Snowden isn't the first NSA whistleblower that we've had. And in 2005, the New York Times, wherein some of you were probably still in grade school, the New York Times revealed that the NSA was spying without lawful warrants as part of the war on terror. And you may remember President Bush at the time saying, if you're talking to a member of Al-Qaeda, we want to be listening. That was the very tip of an iceberg that I think we now all are seeing maybe a couple inches down more of. And what the president didn't say was, in order to be as the first step of trying to listen in to people who were listening in on Al-Qaeda, they were listening to all of us. They were collecting all of our communications records, and that little iceberg, that little tip sat on a gigantic mechanism of surveillance that we still don't know all of. The other thing that happened in 2006 is that USA Today revealed that the government was collecting everybody's phone records. And this was a front page story in USA Today, and it was confirmed by members of Congress at the time. And then the third thing that happened in 2006 is an AT&T technician, Mr. Fine referred to him at Verizon, and it certainly could have been, but it turned out that Mr. Klein worked for AT&T. A low-level systems administrator for AT&T walked into the front door of my organization and gave us the schematics for what we now know as the upstream program, which is the government having direct access to the fiber optic cables that carry up all of our communications, including very specific schematics of a room in a building on Folsom Street in San Francisco where some of this is happening, but also those documents referencing these were the West Coast instructions for the fiber optic cable application. So it references places in San Diego, in Los Angeles, in San Luis Obispo, in Washington State, where similar pairing arrangements and access to fiber optic cables by the NSA is occurring. So I think we have a bunch of poli-sci and law people here. Do we have any technologists in the room? Couple, good, yay. So whenever I give this talk, I try to do two things. If you're a technologist, I'm going to teach you a little law. Don't worry, it won't hurt. And if you're not a technologist, I'm going to teach you just a little bit of technology, and that won't hurt either. But I want to explain to you what a fiber optic splitter does, because I think it's important if you want to understand the context of what's going on here to actually understand the technology, and it's not hard. A fiber optic splitter, so your communications are carried on fiber optic cables. That's a beam of light, right? You might have seen the commercials where you see the little light going in and all of that. This is a modern way that communications travel. Fiber optic cables carry all of your internet traffic. They carry your phone calls. They carry many of your wireline phone calls because the back end of that happens on the internet. Carries all your web searches, all your social networking, basically anything that, almost anything you do over a wire, with some small exceptions, gets carried ultimately over a fiber optic cable. A fiber optic splitter is a very dumb device. A fiber optic, dumb as in it doesn't have any intelligence at all. It cannot do any targeting. It doesn't do any selecting. What a fiber optic splitter does is it splits that beam of light into two. So your communications are being carried. They hit a fiber optic splitter. They're split in two. Here's a cool thing about light. When you split light in two, you don't get halvesies. You get a copy, a full copy of everything that's being carried on that light is made on either side of the split. So in the AT&T building on Folsom Street and in multiple AT&T buildings across the country, there are a bank of fiber optic splitters that sit at the place where your communications go from AT&T to the broader internet. So if you're an AT&T customer and you're emailing Verizon or vice versa, this is the place where these splitters sit. And what happens at these splitters? Well, what happens at these splitters is that beam of light carrying your communication hits a splitter. Two copies are made. One copy goes to its destination, and the other copy goes into a room that you can't get access to unless you have NSA clearance that has very sophisticated machinery. So when I say that the NSA is getting copies of everything that you're doing, that's what I mean. And that's why I mean it. And now you understand too. So the man who was the systems administrator, there's an interesting story to be told here about the role that systems administrators have played in the national security surveillance, because as I like to say, it helps to have friends in low places if you want to know what's really going on in a computer system, and by that I mean root. Sorry, that's a tech joke. The geeks just got it, and none of the rest of you did. Sorry about that. So we knew all of this in 2006. And in 2006, I launched a lawsuit called Hepting versus AT&T to try to get to the bottom of this. Both the telephone records case and the access to the fiber optic splitters were facts in my case in 2006. We were winning this case. But in 2008, you may remember that Congress passed something called retroactive immunity for the phone companies. Retroactive immunity for the phone companies was a bullseye placed on my litigation to kill it, and it did, and 50 other cases along with it, ultimately. But we launched another case against the NSA in 2008 because what was clear was that Congress wasn't going to give NSA immunity, at least not yet, but they were only going to give the phone companies immunity. So we launched this case in 2006 and continued it in 2008. And why do I tell you this? Well, I tell you it for a couple of reasons. One of the reasons I want to tell you this is because I think that a lot of people don't realize that Mr. Snowden didn't reveal for the first time nearly as much as people would like to pin on him. What he revealed was confirmation about a lot of stuff that frankly we already knew about and that I already had in public court records. So to the extent people are angry at Mr. Snowden for revealing inconvenient truths to the nation and to the world, I think we ought to point out that the scope of what he revealed was significantly smaller than I think what people would like to pin on him. And I think that's important when you're trying to charge somebody with treason or espionage. But what did Mr. Snowden give us? What is the new information? Well, I'm just going to tick off a few things because there's way too much to go through it all. But he confirmed the phone records collection in a way that made the government have to turn from claiming that it's a secret to admitting it. He confirmed the fiber optic collection, the fiber optic cable collection that we're talking about, and we now know the name we think of it, called the Upstream program. He confirmed something called PRISM, which is access to the information that's collected by major internet companies. We still don't know a lot about how PRISM works in practice. There's some theories out there. It's a very strange situation. The PRISM program is one in which the government says, yeah, we're getting direct access from the America's internet companies, and America's internet companies are going, no, you don't. It's not, it usually works the other way, right? But so we still know bits and pieces about that, but not a lot. But certainly there is something going on involving the nation's internet companies where they're turning over the information that they have collected about you to the government under some kind of authority, and we have some educated guesses about this. We also saw what this looks like if you're an analyst, right? We saw this thing called X-Keyscore. If you want to know what this looks like if you're an NSA analyst, look at some of the slides about X-Keyscore and see how they can do the searches and how it works. We learned that there's a lot of information sharing happening between the U.S. intelligence services and intelligence services around the world, especially something like the Five Eyes, which is U.S., Canada, New Zealand, Australia, and the UK, English-speaking countries that have a alliance, sharing a lot of information about each other's citizens. We also, and one of the things that we learned about just recently was that GCHQ, the British version of the NSA, was actually turning on the cameras in people's, homes of their computers if they were Yahoo Mail users. And apparently the slides indicate that a lot of people are naked if you turn on their cameras in the middle of the night. Which I'm really, like, what does this have to do with security and why did it make it in a PowerPoint slide? But it did. We also know that for those budding young lawyers in the audience, that the Australian government was collecting attorney-client privilege communications between a law firm called Mayer Brown and Platt that's based in Chicago and their clients in Indonesia. So when you learn about the attorney-client privilege and you learn about how sacrosanct it is and how it's one of the strongest privileges we have in the law, you should note that it's not all that important to the NSA. Now, they claim that once they got it, they've got all sorts of protections about it, but they're all too secret to reveal to us. Makes me feel better. We also learned about something called tipping. We learned that when the NSA has information that it's gathered and it sees evidence of a crime in that information, it can give it to the FBI or whatever other agencies as well. This is called tipping, and it's right in their regulations that any evidence of a crime that they collect on the way to getting the information that they were thinking they were getting, they can hand over to the FBI. So to the extent that people tell you that this is just about counterterrorism and it's only going after terrorists, you can point them to the place in their regulations where that's not actually what they're limited in being able to do with the information. We also learned about something that, for the geeks in the room especially, is very troubling. We learned about sabotage. We learned that the NSA has been dumbing down the technologies that you and I rely on to keep us secure. They've been collecting vulnerabilities. They have a slide that says they're inserting vulnerabilities. We haven't caught them at that yet. In the case of the Heartbleed vulnerability, we haven't yet been able to confirm that the NSA knew about it or exploited it. But what we do know is with other vulnerabilities, the NSA is actually collecting them. They're called 0 days often because you have 0 days to fix it before it gets exploited. That they're collecting these things and they're not telling us about them. So they're finding weaknesses. They're finding coding errors and problems in the technologies with the security of the technologies we rely on, and they're not telling us about them so we can fix them. It's as if the local cop walked by and saw that your front door was ajar and decided to just keep walking rather than to tell you so you could close it and fix it. As Julia Angwin mentioned, we learned that the government is exploiting all sorts of leaky apps and all sorts of security problems in them, that they were, standing in the shoes of the worst cyber criminal you can think of, trying to use the exact same techniques that those people use, which I think is troubling. We also learned about some domestic stuff, and this did not come from Mr. Snowden, but we've learned that there's a program called Hemisphere that the FBI runs where AT&T employees are embedded with a DEA investigator so that they can more quickly search through the AT&T's vast database of your phone records for drug prosecutions. I want to see more research about this, but the other thing we learned about this, and this is one of these great Orwellian terms, we learned about something called parallel construction that the FBI uses, where they basically lie about where they got the information so that the defendant can never tell they think that they got pulled over in a pretextual traffic stop when instead what happened was they were tipped by the FBI or the NSA about somebody's activities, and the actual basis for the further investigation is not revealed to the defendant. Again, for you law students, that idea that you have that you get to confront the evidence against you in a court of law in order to try to defend yourself has taken a pretty big beating with this idea of parallel construction. And if you want to see a pop culture, I'm here in LA, and I got to do a really fun thing in the last couple months, which is the producers of The Good Wife TV show called me, and I gave them some information about some of these things. And there's actually an episode that they ran. They run a couple of episodes based on some of the conversations I had and other people had with them. But they did one called Parallel Construction Bitches a couple of weeks ago, where they play out one of these scenarios in a way that is pretty close to an incident that we know about, and I think did a fairly good job. There's, it's TV. Don't read too closely into it, but if you want to see how parallel construction kind of works in theory, they did a pretty good job dramatizing it, and far better than I could in a little speech, because I'm not Juliana Margulies. So let's talk a little. So those are some of the facts that we know about. Those are some of the things that we know about based in the last year or so. What do we know about the law here, or at least the government's theories? Let's start with that. The thing that's fundamentally going on in these mass surveillance technologies, and not the targeted ones, but the mass surveillance technologies, is really kind of a flipping around on its head in the way that law enforcement ordinarily does business. Ordinarily, and frankly, I would argue under the Constitution, law enforcement starts from a lead and then develops evidence around that lead. And what we've seen now is the government is collecting a massive amounts of information first and then sorting out second what they actually need. This is why I say it's flipping it on their head. So why do I think that's a problem? Well, I think we start with the Fourth Amendment, and Bruce Fein talked a little bit about the Fourth Amendment. I don't want to just repeat what he said, but he said a lot of good things, and he throws in amazing quotes from the Founding Fathers. He's really good at that. But the Fourth Amendment did come from the basic historical precedent that the government was doing untargeted searches. They would get a warrant based upon the fact that a crime had been committed, and that empowered them to search anybody they wanted for evidence of that crime, rather than having a target, a lead, an identified person that they had probable cause to search. That is actually the historical basis of the Fourth Amendment. And the way the Fourth Amendment works is that the first thing you have to decide is it a search or a seizure? And then if it's a search or a seizure, then the government has to show probable cause or particularity and reasonableness, or that an exception applies. So I'm not going to get too deep in the Fourth Amendment. You guys the law students are going to learn it, and the technologists, you can find other resources for it. But I want to kind of frame the way the government thinks about the Fourth Amendment here. The government's argument is, first of all, it's not a search or a seizure on this question of, is it a search or a seizure to begin with under the Fourth Amendment? The government says, no, it's not if it's metadata. It's not if it's not the content of your messages. And the basis of that is the Smith case, which we talked about a little while earlier, where the government was able to get the phone records of one guy for a couple of days who the government thought was making harassing phone calls against a woman whose purse he'd stolen a couple of days earlier. That's what Mr. Smith was charged with doing. And so I would submit that there's a couple of things wrong with relying on the Smith case here. And the first ones are just kind of the basic factual predicates here, which is they're spying on everybody who's not a suspect every day for 5 years at a time, keeping the information for 5 years at a time. That's four pretty big distinctions from the Smith situation. The second thing the government says is that it's not a search under context of the Fourth Amendment if a third party holds that information. And we heard a little bit about that this morning from Julia Angwin and other people, that Justice Sotomayor, especially on the Supreme Court. But frankly, I would argue, depending on how you count, a majority of the Supreme Court is pretty uncomfortable with this idea that the minute you give some information to a third party, you lose all constitutional privacy interest in it. But that's the government's contention. So that's the Fourth Amendment context in which we're talking about. But I want to be clear. The surveillance techniques that I talked about, the two that are core to my Juul lawsuit, one of them is metadata. That's the phone records case. That's non-content. But the other one, that access to the fiber optic cables that I explained to you, that collects content. That collects everything. Why? Because the splitter doesn't discriminate. It gets everything, and the NSA gets custody of everything. So even if you buy the government's argument about metadata for the records program, it doesn't answer the question for the content collection that they're doing. Now, let's talk a little bit about the First Amendment. This is the central theory in the other case that I brought, the First Unitarian Church of Los Angeles. The First Unitarian Church of Los Angeles here versus the NSA. The First Unitarian Church is a case that's talking specifically about metadata, about that Smith versus Maryland problem, the content problem. And it's an interesting thing because in the context of the Fourth Amendment, there is some doctrine that says metadata doesn't get as strong a protection as content. But in the First Amendment context, that distinction doesn't work for the government. Why? Because we have a case called NAACP versus Alabama. How many people have taken First Amendment of my law students here? Nobody. Oh, this is a great case. You're going to really love it when you get to read it. The NAACP versus Alabama is a case from the 1950s where the state of Alabama, and frankly a lot of states in the South, required the NAACP to turn over their membership lists as a condition of operating in the state. And the U.S. Supreme Court said something fairly obvious, which is you have a right of association that's part of the First Amendment, and if you require an organization, especially an organization that's working for social change, to turn over its membership lists to the government, nobody's going to join it. You're going to chill people's right to associate for this cause, for the NAACP's cause, if their information is being handed over to the government. And we have a modern case in the Ninth Circuit here that made that same decision. It's the Prop 8 case, where the proponents of Prop 8, that's the gay marriage case that got overturned by the Supreme Court, but the proponents of Prop 8 were not held to have to turn over all the people who'd given them money, all the people who'd given money towards Prop 8, on the grounds that people wouldn't give money to support a political cause if they knew that that information was going to be handed over in the context of a civil discovery fight. So it's an old case, NAACP versus Alabama, but we have a very recent precedent here in the Ninth Circuit. I should mention that EFF is based in San Francisco, and my cases are pending in the Northern District of California Federal Court in San Francisco, and so we'll go up to the Ninth Circuit. So based upon this right of association, but the other thing that, what is a membership list? I'll tell you what a membership list is. It's metadata, right? It's not the content of your communications with the NAACP. It's the fact that you associate with the NAACP. It's metadata. So I submit that the government collecting everybody's phone records and tracking everybody's associations is a digital equivalent of the same problem that the Supreme Court was grappling with in the NAACP versus Alabama case. And in the First Unitarian Church case, we gathered 23 organizations that work for social change on one level or another, all of whom have stories to tell about how people are afraid to call them now because they know the NSA is collecting their phone records. And they range from the church, which has a great local presence here, to the People for the American Way, to Human Rights Watch, to the California Gun Owners Association, to the Students for Sensible Drug Policy. There are 23 organizations involved in this, and I will tell you that they do not agree on anything, except that they all should be able to organize to try to make social change without having to have that information routinely conveyed to the government. So that's our First Amendment argument. And that's fully briefed in front of Judge White. We're waiting for a hearing date in California, in San Francisco. If you get into the First Amendment context, once you've demonstrated there's a First Amendment issue here, I feel like I have to do doctrine if I'm speaking at a law school. Once you're in the First Amendment box, because there's a right of association, then you have to trigger the test called strict scrutiny, which means the government has to narrowly tailor its program to meet its end. And we would argue that mass collection of everybody's phone records when they know that the vast majority of those people are innocent people is not narrowly tailored for purposes of the First Amendment. So that's how I think we win this case. I can talk through if people have questions about the statutory basis. They talked a little this morning about Section 215 of the Patriot Act, which is how the government thinks that it can do the phone records collection. There's lots of problems with its interpretation of the statute. The government maintains that the upstream collection I told you about is justified by something called Section 702 of the FISA Amendments Act. And the argument the government maintains there is because they're targeting somebody abroad, it's okay that they're collecting a lot of information about Americans here. They call that incidental. By incidental, they don't mean if you look in the dictionary under incidental, there's actually two definitions, and one of them is kind of tiny and unintended, and the other one is not your main target. They mean the second one. The second definition of incidental. I would argue that that doesn't meet the statutory standards either, which are pretty clear about the government can't intentionally design a system that collects the information about Americans. And by any measure, fiber optic cable splitters are intentionally designed to collect everything and contain no targeting. So that's a kind of a thumbnail on Section 702. I just published a blog post yesterday that goes into that in detail. People have focused a lot on the phone records program, and that's really important. But unless we address the upstream and the massive access to people's communications and communications records together, we're only going to just be a drop in the bucket against the government's surveillance. So what is EFF doing? We have the Jewel case, which has both the phone records in it and the fiber optic splitter. We have the First Unitarian Church case that I talked to you about that was filed last July. The Jewel case was filed in 2008. And contrary to the belief of everybody who seems to be east of the Mississippi River, we have never lost that case. We've won it every step of the way. It's just been really slow. We had a setback. It got reversed. We've done a lot of FOIA work along with our friends at the American Civil Liberties Union and a bunch of other organizations trying to squeeze as much information out of the government as we possibly can. The government now has a Tumblr account called IC on the Record. And I don't think that they figured out that if you read that, it says icon the record. But anyway, sometimes you got to wonder, how'd that make it through the committee? But anyway, the Tumblr account has a whole bunch of information, including a lot of FISA court decisions, secret court decisions and stuff, that the government proudly announces that it's being more transparent. I would submit to you that underneath most of their new transparency is a FOIA case and pressure from either us or our friends at the ACLU to get them to cough up some of this stuff. But I'm glad it's coming out, and I really don't need the credit for it. There's also several criminal cases that are being brought as a result of the mass surveillance, where the government has finally, after lying about it for a very long time, started notifying a few defendants, and I think they're still select defendants and not all defendants, that some of the secret evidence, some of the NSA surveillance was being used as part of building the case against them. And EFF, along with, our friends at the ACLU, we tend to work on this stuff together a lot, are trying to bring amicus briefs to get courts to take a hard look at where that evidence came from and whether it was properly collected. We haven't talked much about international here, but EFF is part of quite large group called the Necessary and Proportionate Group that is trying to think about how international human rights law and international law should apply to what the government's doing. We've got some principles called the Necessary and Proportionate Principles that honestly we started writing before the Snowden revelations, but to try to think about how existing human rights law, which does include the right to privacy and includes the idea that you have the right to privacy regardless of what country you're a citizen of, and how that ought to be applied to the tools of mass surveillance. the principles are being picked up by international efforts kind of all across the world now to try to set a basic framework for how we should think about this kind of effort. There's over 500 organizations worldwide who have signed on to them, and they're getting kind of name checked in various international authorities. So if you're interested in the international piece, and I think it's a really important piece, one of the things that I think has been frustrating for a lot of the companies who are involved here, and I think a lot of the people who are involved here, is that when the U.S. government was revealed to be doing all this spying, what they said was, you don't have to worry about it because, we're just targeting foreigners. We're not targeting Americans. And I just don't think that's the way America should be in the world. I think we ought to be a leader in respecting the rights of people around the world. And, it doesn't mean that everybody around the world gets the right to vote, but it should mean that they have some measure of protection against being spied on by foreign governments. And I think that not only because I think we ought to be a shining light for protecting rights around the world, but because it creates a pretty rotten race to the bottom. If we can spy on other countries' citizens, then other countries can spy on us with impunity and without any recourse or remedy for us. We're doing one case now where we're trying to strike back against this. We actually caught the government of Ethiopia installing spyware on the computer of an American living in Maryland, American citizen, who was born in Ethiopia but has had asylum and lived here as a citizen for well over 40 years. And sued him for wiretapping, illegal wiretapping. We sued the government of Ethiopia. So hopefully we can begin to strike back a little bit about that. But you have to pay attention, I think, if you're going to think seriously about this, not just to what do you think about the U.S. government spying on everybody, but what do you think about every government in the world spying on everybody? Because that's actually, that's where this heads, and it heads there. It's already there. What else is EFF doing? Just a couple more things where we build technologies at EFF. We built a tool called HTTPS Everywhere that helps secure your browsing when you go online. We built something called the Observatory, which helps check these things called certificates, which is part of how you have security and can trust that when you go to your bank, it's actually your bank, to try to track those certificates, which is one of the tools we know that both bad guys and the NSA use to try to trick people into giving up their passwords and other information. We support technology projects across the world. We support something called Tor, which I think you saw in one of the professor's slides this morning, which is a way that you can also browse the web securely and do a lot of other things with Tor. Tor was in-house at EFF for a few years, and they rolled out into their own nonprofit, but we still help them quite a bit with issues. Because I do think that we're not going to solve this problem merely by law or merely by policy or merely by technology. It's going to take all of them working in the same direction in order for us to be able to claw back a little bit of privacy and a little bit of security in this age. And I think one of the things I would urge you is anybody who tries to tell you, oh, well, we need to choose. We either do a policy change or we do a technology change or we do a legal change. And the answer is no, we have to do all of the above. And the reason we have to do all of the above is because that's what the NSA has been doing. So if we're going to bring the pendulum back, and the good news is that over 50% of Americans now think that the pendulum has swung too far in favor of NSA surveillance, and it's time for it to swing back. So we have a majority of Americans who are concerned about this now. So what we need to do, and the charge for me and other people who've been worrying about this for the longest time, is to try to figure out how best to marshal that and bring about the world that we want to live in. So that's my basic pitch. I'm happy to answer questions. I have a whole little section where I talk about all the things that people say about spying and why it's okay and why there's nothing you can do about it. But the professor this morning did such a great job. I think I just want to steal what he did. So I'm happy to answer questions. I'm happy to talk more about what EFF is doing and other things. And I can pretty much tell you, I suspect Dianne Feinstein wouldn't have agreed with almost anything I just said. Thanks.
Hi. Oh, it's falling.
Oh,
It's okay.
Shrinking.
I got this.
Yeah.
Okay, so I, along with some kids from Professor Lebo's class, read Daniel Sala's book, Nothing to Hide. So we're familiar with all like the fallacy arguments, as we like to call them. And specifically, I studied a lot the Electronic Communication Protections Act. So a lot of that, a lot of people like to blame, the USA Patriot Act, when really there was just, fault with that law and those statutes within it, and the excuse me, and the security letters to begin with. But like you said, it's going to take more than just, revisiting those and making more inclusive laws. So when you're saying it's going to take all of the above, what other measures do you think that we can do as students here at UCLA, other than just trying to support the passing of more protective laws?
Well, that's absolutely important, and you're certainly correct that the problems with ECPA, the Electronic Communications Privacy Act, and NSLs and lots of other things, it all went into the mix. And the Patriot Act is a funny law because it actually made changes in a whole bunch of different areas, including in ECPA, along with FISA, which is the Foreign Intelligence Surveillance Act. So, I work mainly in the courts. And so, because I think that we have a constitutional problem, at least in the government's view right now, and we need to fix that. So it's a little hard for students to participate in a lawsuit, but if I end up down here in Pasadena for oral argument, I hope you guys will come out. We did one down here. I think the other thing to do is to educate, get students talking about this. As I said, we've got over 50% of the American people who are concerned about this. And I'll tell you, the number one argument that I get from people over 50 is kids today don't care about privacy. And I think that having kids today say, hell yes, we do, is really important, and doing that in a lot of different areas. And I think there's an education process that needs to happen, because I think that a lot of people, well, first of all, there's been a lot of media hype around kids, which happens every generation, right? Every generation's kids are going to rack and ruin because they don't believe in the value. It was the pool table that arrived in town, right, in the Music Man. So it's not new, right? But it is happening, and I think it's happening to your generation. And I think that one of the disconnects that's happening is that a lot of older people think that privacy is about the quantity of information you share rather than who has control over the information you share and where that information goes. And I think we have to have a national discussion where people understand about privacy the way I think a lot of kids understand about privacy, which is I'm perfectly willing to share more facts about myself than maybe my grandmother is, but that still doesn't mean that I want my mom to see, or that, you still want to be able to control who the audience is, not just the primary audience, but the secondary audience for that information. So I think students speaking up and talking about this so that we can combat that, I think, myth about young people, and really come together to a new understanding about privacy would be really important to this dynamic. I'll tell you, I go talk to, like, if it's and I got silver hair, a silver-haired crowd, the first thing is, why should we care about the NSA? My daughter's, my granddaughter's on Facebook, and she's talking about what she had for breakfast. And they don't understand, I think, the way that younger people who grew up with technology, those two things are not connected at all. Whether the NSA has access to my data and whether I'm going to publish what I had for breakfast are two very different questions, and they're getting combined in some people's minds. So that's one thing you could really do to help me out.
No, that's a good point. We get that a lot.
Yeah.
Thank you.
Hi, thank you again for coming. I just wanted to say that, I'm the president of Young Americans for Liberty at UCLA, and so we're a big fan of the work that the EFF does. So thank you again. We consider you guys to be true patriots, definitely. I guess my question is, obviously, since, a lot of the government's actions, like you were mentioning with the retroactive telecom immunity with the FISA laws, sometimes targeted against what the EFF and other groups do. Have you faced, well, obviously you can't necessarily confirm, I guess, if it's coming from the NSA or not. Has your organization faced any kind of cyber attacks or other harassment from any sources, and how do you deal with it?
We haven't, that we can track back. There's a lot of bad actors on the internet. It's really hard to tell if the bad actor has got a government hat on or not from the from things. I would say in general, EFF isn't attacked very much. I think it's really, you know, a couple of reasons. One of them is it's massively uncool if you're a hacker to attack the people who may defend you if you end up getting prosecuted. And I think a lot of people get that. I think that from, you know, and no, we really haven't seen, I mean, I suspect we're under surveillance is that, you know, Mark Klein was the original whistleblower and he walked into my front door. So if you're a government agent and you're trying to figure out where the next whistleblower is going to show up, my front door is not a really bad place for you to look, right? It's where it happened once before. So I suspect there's surveillance of EFF. We certainly, and we take precautions. You know, I have a good tech team. It's hard to do operational security, as Julia, she left, but can tell you it's actually really hard to have a nimble, smart, technically savvy organization that also has the best operational security you can have. Those two things do actually conflict sometimes. I don't think security conflicts with privacy, but I do think security conflicts with cool tools sometimes. So we haven't, you know, to the extent that we have, it hasn't been something that we've been able to identify. I also think because we're in the courts, it'd be pretty stupid for the NSA to get caught spying on us because I've got a federal judge that, you know, I'm actually suing them in a court of law, trying to bring this before what I think most people agree are the proper ways to, you know, whether you think I should win my suit or you think I should lose my suit, I think most people don't think it's illegitimate for me to try. It would really undermine their position if they were to be spying on their legal opponents. That doesn't mean that they're not doing it. It means that I suspect that there's a lot of carefulness about that. So.
Thank you.
Hi there, I'm Lucas. I just want to know, because this is obviously a very complicated issue, and even though many more Americans are getting interested into it and developing an opinion, there are many others that are obviously still uninformed about the issue and all its complexities and, you know, changes in policy and law and technology. So I was wondering if you could recommend for us and people in general, like resources we could look into these changes in law, technology, and policy that go into the issue, just to better understand this issue as it develops.
Well, I mean, I, of course, have to start with EFF's blog, where we write a lot, or our Twitter feed or whatever. We do a lot of public education. Our friends at the ACLU do some great public education. They've got some really fun videos, actually, kind of trying to demonstrate this. You know, watch The Good Wife. Now they don't. They sent me flowers. Honestly, I don't get paid for them or anything, but and a mug. But I think that honestly, I think the newspapers, I mean, you know, The Guardian and The Washington Post especially have been doing a lot of the breaking news here. They do a really good job, and a friend of mine, a guy named Ashkan Sultani, advises with the Washington Post on a lot of their stories, and he does a pretty remarkable job. They do graphics and explainers. There's a lot of interactive stuff where you can see how this works. I actually think the newspapers have done a pretty good job explaining this. Julia's book is great. It's not, as she mentioned, she kind of had it done before the NSA stuff really hit, so it doesn't hit the NSA stuff as much, but it kind of, because we know that the government is exploiting the same technologies that she talks about in her book, it can give you a good starting point for some of what's going on. So those are places that I do. But honestly, this is breaking news. So I think the newspapers and looking back over time in the newspapers is really still the best places. There's some books coming out slowly, but it's still moving too fast for that.
Thank you.
Thanks.
Good afternoon. One quick question regarding contingencies. Regarding the First Unitarian case, supposing you win or supposing you lose, what is the next legal step that your organization intends to take, and what sort of test case are you looking for?
Well, they're both my test cases. The Juul case is actually a class action on behalf of all of AT&T customers. So if we win, if we win either First Unitarian or Juul, I think the government will appeal. It'll go to the Ninth Circuit Court of Appeals and then may go to the U.S. Supreme Court. So I don't think they're going to end anytime soon. I mean, I'd love it. It'd be really great if tomorrow they were like, you're right, we're all done. And then I have a long list of other things I'd like to do. Other test cases we're looking for, I would be very interested in trying to find some of these vulnerabilities and trying to figure out if there's a way to draw attention, maybe a court case, but otherwise to the government's activities in making us less safe. I think that's tremendously important. I haven't thought about test cases past these. I think I'm just too mired in my two right now. It's a good question. I don't know. If you have ideas, send them to me.
Thank you.
Hi.
Hi.
I'm curious if there are any tech companies or firms, emerging technologies that EFF supports in the context of privacy. Like, I have an Android phone. I formerly loved Google. And I, like what you said, really hit home about how kind of fun toys and security tend to have tension.
Initially, hopefully in the long run they don't. But.
Yeah, I'm kind of wondering about that long run. Do you see anything on the horizon? Is there anything that we can look forward to that's not like a brick?
I mean, we know a few things. We know that open source tools are more secure than closed source tools. That's always been the case, and now we really know it because we've got like government slides complaining about how they can't break Tor and how they can have access to all the proprietary systems. So that's good news and it's bad news. It's good news because if you're really, really geeky, there's really cool stuff, and it's bad news because if you're not really geeky, open source stuff can be actually very difficult. If I had, a grant of like $10 million, I would open the Open Source User Interface Consortium and hire all the people who build the Apple interfaces and some of the other cool interfaces I've seen up there and get them to help us make open source more usable for mere mortals. This is not a surprise to the techs in the room. I helped free up encryption technology from government control in the 1990s, and it still sucks to use a lot of it. We don't tend to endorse products, but there are some, or companies, because we don't really want to be in that business. But so the things you want to look for is it open source? That means maybe that you can't check whether it's worked, but somebody else can, and that's a great disincentive and way that you catch bugs. I mean, people often, the Heartbleed virus was something that was found in an open source security library. And I've had people come up to me and say, well, Heartbleed was an open source library and it had a vulnerability in it, so therefore we shouldn't use open source. And the answer to that question is no. We found it because it was open source. If it was closed source, we still wouldn't have found it. And the closed source tools that you guys are relying on, dollars to donuts, have significant security vulnerabilities in them that you just can't, nobody will find. So look at open source. There's something called OTR, which is a back end for secure chat, and it works with Google Talk, it works with AOL Talk, it works with its own things called Jabber. The Windows front end is called Pigeon. The Macintosh front end is called Adium. That's a very secure technology that you can use for chatting online. There's a few other things. DuckDuckGo is a commercial company, but they were built with the idea of not keeping people's information. But EFF is about to come out, hopefully in the next month or so, with something called Security Self-Defense, which will be actually a chart kind of comparing a lot of these technologies that ought to be useful. There's also an organization called Tactical Tech that does something similar where you can kind of look at technology. I mean, they're really aimed at human rights workers, journalists, people who really need strong operational security. So some of the things that they recommend are a little bulkier and harder to use, but there's efforts to try to make that stuff better. There's a thing called Jitsi, which is an open source thing that's trying to do what Skype and Google Hangout do. It's still a little glitchy, but it does work okay. Honestly, Google Hangout and Skype are pretty glitchy too, if you're, so the bar's low. For most of the commercial tools that you use, there is probably in development an open source, cool, free, more secure one. it's just where they are in terms of development and whether they're really ready for prime time yet.
Thank you.
Hi, Cindy. I just have a question. As you know, after the Snowden leaks came out, the White House this last year issued a memo of recommendations, and one of them was actually to have the FISA court have opposing counsel, and it seems such an ironic recommendation considering how would they create opposing counsel that could be unbiased is what I was trying to say. And I was just curious what you thought about that, and is that even just a realistic option?
So I didn't talk about legislation very much because I think Mike German's going to talk, and I assume that he's going to talk a little bit about the bills. But there's a bill called the USA Freedom Act, which is by Leahy and Sensenbrenner, that has a bunch of good things in it. We've still got a couple things we need to fix to make it where it needs to be. But it has a whole provision in it about trying to create some kind of a second voice inside the FISA court. It's actually not bad. Look, it's going to be imperfect. But trying to create an independent voice inside a secret process is difficult, but I think it's better than nothing. And right now, remember, we're at nothing. I mean, I'm not a fan of the FISA court, and I wasn't a fan of it even before it turned from being this very narrow court to the kind of broad procedural stuff that it does now. I think that the regular federal courts can handle these kinds of warrants, and we don't need a secret court for it. But trying to create some kind of an adversarial process inside the FISA court isn't a bad first step. And there's some proposals. There's some proposals for making them independent. There's some proposals for, how classification works, for what cases they get pulled into. It could be good. It's not going to be perfect. These are all just Band-Aids. But I'm supportive of trying to think that way. I think smart people can devise something that will actually help a little bit and stop some of the mission creep that we're seeing.
Thank you.
Okay, I guess since I'm the last one, I have to make it good. My
Yeah.
name's Tim. I was in Professor Lebo's course that led to this symposium. So my question, or really it's like a three-part question, is first, given your work in the court system and cases around the country like Clayman v. Obama and ACLU versus Clapper, what do you think is the timeline for SCOTUS, the Supreme Court, to give us a decision on telephone metadata and the other issues that you've raised in your discussion here today? Secondly, do you think that the makeup of the Supreme Court will find in favor of overturning the metadata, or do you feel that we're kind of walking a fine line considering some of the justices' opinions in recent technological questions? And lastly, against, I guess, the race between legislation and the courts in defining and working with this issue, which one do you think will have a decision or opinion beforehand? I know that there was a memo released back in December and it was discussed in January, but do you think the courts will be the first to implement systems, or do you think the legislature will be able to combat it and maybe overturn some of these cases that you've discussed?
So I'll tell you a little something about EFF, is that we're all betters. And we have a whole bets page on EFF. Usually it involves bourbon if I'm betting. For other people, sometimes it's dinners. I did have to buy vegan sushi for one of my technologists recently. So we bet on lots of things. And this is one of the things that we're trying to bet on. And I say that by way of saying, I don't know. And nobody does. I think that the one thing that happens when something's moving in the courts and in the legislature is that they spur each other on. Judge Leon's decision was one of the best things that ever happened for moving things in Congress. When something starts moving in Congress, it gives the courts the confidence to step up, because if they hear that there are a lot of legislators who are concerned about it, they don't feel like they're so out on a limb. So I think they're mutually reinforcing. Who's going to go first in terms of doing something? It's hard to know. The ACLU's Clapper case is the fastest moving one right now. They just filed their last brief. The reply brief was filed by the ACLU yesterday. I just read it on the plane on the way down here. It's very good. They're really they're doing it's a great job. We filed an amicus brief in support of them, talking about how metadata is very revealing. that could end up being the quickest thing. It's a preliminary injunction. It's moving fast. My Judge White, who I think is a fine judge in the Northern District of California, is the pokey little puppy with regard to the courts right now. Oh, don't tell him I said that. But moving much more slowly. So I think that one has the chance. The Clayman case is also up in the courts of appeal. I don't think they've started the briefing yet in that. So of the cases, I think the ACLU is moving the most quick. But I've been litigating now for 25 years. You really can't predict how things are going to move. We have a preliminary injunction in the First Unitarian case. If Judge White were to rule, we could get up very quickly. We already have a panel in the Ninth Circuit who's heard our case a couple of times, and we may be able to leapfrog up. It's possible. So I don't know, and neither does anybody else who tells you that they do. Is the answer to the timing. In terms of, how do we think the 9 are going to vote on this, and will it be the same 9 by the time we get up there? I was very cheered by the Jones decision. In the Jones decision, we had 5 judges who were very concerned about sustained surveillance, right? I mean, the Jones case turned on a physical trespass, but there are 5 of those judges who were concerned about the sustained nature of the trespass and not of the surveillance, and not just the fact that they touched a car. So I think that's hopeful. So I think you can get to 5. I'm not sure you'll get to 9, but you can get to 5. It really turns on, Justice Scalia has been really solid on these issues. And so it creates, I think the surveillance issues are very interesting because it really doesn't break right left. It breaks, the My Coalition and the Tea Party people are right alongside the, ACLU and People for the American Way, trying to stop the spying. I mean, that just doesn't happen all that often. And it's an important thing for us all to recognize. I think that may play out the same way in the Supreme Court. It could go horribly wrong, but you don't have any rights unless you try to stand up for them, right? The way that you can demonstrate for sure that you don't have any rights is just let them slip away. So that's our only other choice.
Well, thank you so much, and I guess I'll turn it over to Professor Lebo, but thank you for your being here.
Thank you.